Hello, dear friends. In the second lecture of the Erasmus Ecclesiastical Law of spring semester, I continue the explication of the Article 13 on religious liberty in the Greek Constitution. We read in this third paragraph, the ministers of all known religions shall be subject to the same supervision by the state and to the same obligations towards it as those of the prevailing religion. So, the topic of this paragraph 3 is that of the supervision by the state of all the religious ministers, either of the prevailing religion or of all known religions. And it says that the supervision must be the same for all known religions and for the prevailing religions. Despite the fact that this disposition is a constitutional one, it does not have any meaning because the supervision by the state of the prevailing religion must not be, in fact, the same with all known religions, because prevailing religion is a state religion, but all the other religions are free religions. We go now to the paragraph 4. No person shall be exempt from discharging his obligations to the state or may refuse to comply with the laws by reason of his religious convictions. This paragraph 4 contains two limitations to the right of manifestation of a religion or a belief. As we have seen in the paragraph 2 of the same Article 13, this paragraph 2 recognizes the freedom of worship, but as we have said already in our first lecture, the freedom of worship is a form of the freedom of manifestation of a religion or belief according to the international standards of religious human rights. So, we have to understand the term freedom of worship as freedom of manifestation of a religion or a belief. That is, we have to give an extensive explication using this method of interpretation of law. And as we have seen in the second paragraph, there were, except the recognition of the rights of manifestation of religion and belief, there were two limitations, constitutional limitations, to the freedom of manifestation of religion or belief: public order and public morals. Some scholars say that proselytism is another, the prohibition of proselytism is another form of limitation. It's another limitation to the right of manifestation of religion or belief. But as I have explained already in my first lecture, the prohibition of proselytization is not a limitation to the freedom of worship of religion or extensively to religious manifestation, but a special limitation to a concrete only form of religious manifestation, that is only to the freedom of teaching a religion or belief. Now, in the paragraph 4, we meet two other limitations to the freedom of manifestation of religion or belief, because if, as I have explained already in the first lecture, the freedom of religious conscience or religious beliefs is unlimited. No person shall be exempt from discharging his obligations. Not exemption from discharging one's obligations to the state is the third limitation. No person may refuse to comply with the laws by reason of his religious convictions. Obligation to comply with the laws independently from one's convictions. These are the two additional limitations to the right of manifestation of religion or a belief. Non-exemption from discharging one's obligation to the state or obligation to comply with the laws independently of one's religious beliefs we can say that these limitations correspond to the, and must correspond to the other three limitations of religious manifestation under the international law of religious human rights. That is, public safety, public health, rights and freedoms of others. The question concerning the military service has a relation with the limitation of non-exemption from discharging one's obligations to the state. But in the Greek constitution, as in other countries also, there is the possibility of defending the country through an alternative service. And for this reason, the application of the conscientious objector is examined by a special commission of the Ministry of the Defense according to the relative legislation on this matter. As it concerns the obligation to comply with the laws independently of one's religious convictions, the legal theory say that this obligation to comply with the laws independently of one's religious convictions concern the laws of general applicability, as for example the code for the circulation or the code for building. And now we go to the paragraph 5th of the Article 13 on religious freedom. We read in the paragraph 5th, no oath shall be imposed or administered exempt as specified by law and in the form determined by law. This constitutional provision does not create today problems because except its religious alternative, now exists a civil alternative for the people who have to give an oath, either when they assume a public office or post, or when they have to give an oath in court, any kind of court, according to the code of procedures, civil procedure, penal procedure, administrative procedure. The Article 4 of the Greek Constitution says that all Greeks are equal before the law. This paragraph 1 of the Article 4 protects the right to equality of the Greek citizen. It would be better to protect the legge ferenda, the equality before the law of all the people who have the Greek citizenship or live in Greek territory, either legally or not legally. That is, it will be better if it could protect the equality before the law of all the men, of all the people. But according to the list of human rights incorporated in the Convention for the Functioning of the European Union, there is a relative disposition which extends the right to equality before the law to all the European citizens. And according to the Article 26 of the International Covenant on Civil and Political Rights, this right of equality before the law is extended to all the people on the Greek territory. And now we go to the Article 3, which concerns the so-called prevailing religion. We read in the paragraph 1, the prevailing religion in Greece is that of the Eastern Orthodox Church of Christ. The Orthodox Church of Greece, acknowledging our Lord Jesus Christ as its head, is inseparably united in doctrine with the great Church of Christ in Constantinople and with every other church of Christ of the same doctrine, observing unwaveringly, as they do, the holy apostolic and synodal canons and sacred traditions. It is autocephalous, and it is administered by the Holy Synod of sharing bishops, and the permanent Holy Synod originating thereof and assembled as specified by the statutory charter of the Church in compliance with the provisions of the Patriarchal Tome of June 29th, 1850, and the Synodal Act of September the 4th, 1928. Now we proceed to the explication of this Article 3. First verset. The prevailing religion in Greece is that of the Eastern Orthodox Church of Christ. What is the meaning of the term prevailing religion? As it concerns this term, the scholars have supported different opinions. One opinion says that this term means the religion of the majority, culturally majority. And because the principle of majority does not play any role in the implementation of human rights, so this term expresses statistical data in a general manner, according to which the majority of the people in Greece believe in that prevailing religion. So this opinion does not give any legal meaning to this constitutional term. Another scholar opinion says that the term prevailing religion must not be interpreted. It has not any meaning. It is not a juridical term. A third, and before passing to the third, I would like to add that this second scholar opinion has been influenced by the French model of church and state relation, that is, of the separation between church and religions, and état laïque. État laïque means that the state does not recognize any religion, and it maintains the minimum of relations with the religions. The third scholar opinion says that the term prevailing religion means state religion. This scholar opinion is adopted by the minority of the scholars, but it is the correct one, because what it is interesting for us is above all the interpretation of this term given by the government and the parliament. Of course, the government and the parliament does not give any scholar opinion on the interpretation of this term, but the government and parliament interprets this term through their policy on church and state relations. When the parliament and the government proposes a bill on the constitutional charter of the Orthodox Church of Greece, and the parliament adopts a parliamentary law on this statutory charter, when this is done, then we can conclude that the government and the parliament adopts in practice, in legislative practice, the opinion that, not the opinion, but the policy, which is an opinion in practice, in legislative practice, that this term prevailing religion means a state religion. Because when the statutes of a religious group are adopted by the legislative body of that group, then we speak about a free church or religious community. But when a parliament adopts the statutes of a church or religious community, this church or religious community is not a free church, is a state church. This is the difference between a free and a state church. Who enacts the statutes, that is, the statutory charter of the church of or religious community. But there is also a fourth scholar opinion which supports that this term, prevailing religion, is not the recognition of a state religion, but it constitutes a special constitutional recognition for the so-called prevailing religion. As in the constitutions of Italy or Spain for the Catholic Church. But the scholars who support the opinion that the term prevailing religion means state religions, respond that this fourth scholar opinion is not correct because in the Constitution, Article 72, it is said that the Parliament in its plenary session adopts the laws, including the Articles 13 and 3 of the Constitution. That is, the Constitutional Charter provided in the Article 3, Paragraph 1, the Constitutional Charter of the Orthodox Church of Greece has to be adopted, has to be enacted by the Parliament in its plenary session. But as it concerns the answer to be given to that opinion of the scholars who say that the term prevailing religion means state religion, and that the fourth scholar opinion on the special constitutional recognition of the Orthodox Church of Greece, or correctly of the Orthodox Church in Greece, is not correct. I have to respond to this scholar objection to my third lecture, because the time of the second lecture has passed. Thank you for your attention.